Hello, everyone. My name is Dwayne Kimball, owner and founder of KMB89, a VA claims consultant, leave no vet behind. And also, I am a United States Army veteran. Today, we are having a roundtable in which we will be discussing the protection rule. Our guest speaker today is Betty. She is a 35-year plus retired VA employee. A lot of you that may follow me on YouTube, a lot of the information, my knowledge of what I know, she taught me. And I always tease her, she's like a walking dictionary. So the things that I'm talking about, she was very instrumental in my VA career. She was somebody that I always went to when I had questions when I was a young grader and even right before I retired, and I trusted her judgment. So she has a lot of information, and she's been so gracious to join us today. And she is going to be talking about the protection rule, okay? And this is something that I tried to explain in one of my videos, and I was like, hey, do you mind coming on board and talking about this? And she said yes, because there's a huge myth out there on YouTube. The veterans are 100% PNT, they come back in, the VA is going to look at everything. So she's going to talk about that. She's going to talk about some other stuff, and she's going to debunk that myth. She's going to talk about some regulations and stuff. Okay, so it's just not her saying it; it's what's within the VA guidelines. Okay, so with that being said, let me introduce Betty. Betty, go ahead and unmute your mic. Can you? Yep, go ahead and unmute your mic.
Can you hear me?
Yeah, I can hear you.
Hear me?
Yes.
Okay. All right. Like I said, I apologize now for not being on camera, but I'm having some technology issues. But as Dwayne, first of all, let me say thank you. I'm honored to be able to speak to you guys today. My name is Betty Belcher, as you can see. And I did have the privilege of serving veterans at the Department of Veterans Affairs on the benefit side for more than 36 years. I just recently retired in May, and so I still am fresh with those things that are related to rating issues. I'll say I began my career as a temporary file clerk, and I literally worked my way up through all the various positions to actually becoming a rating quality review specialist, as well as I served as a decision review officer on the appeal side. So I have some knowledge, just a few things, okay? So I just wanted to put that out there.
And
I don't know how you guys...
Excuse me 1 second, Beck. And for those of you, when she says appeals, it is called high-level review. So if you have if you're doing a high-level review, the persons that do that are decision review officers. So that's what she meant, okay?
On the rating side, for the rating purposes. Let me say that, because the higher level reviews for other issues are done by someone else, not actual decision review officers. Oh. So that's just for clarification. I was trying to decide, I think I'm going to talk about each particular rule, and then if you have questions, so we can kind of go in order and not confuse things up too much. So what I would like to talk about first is what we call, it's called the tenure rule usually, okay? And that actually, and if you want to take a note, it's covered under 38 CFR 3.957. And if you want to wait and grab a pen, I can wait.
I think we had one person that went to get
I did see. No,
okay.
I'm looking. I'm trying. I'm trying.
Okay, he's back.
Okay, I'll say it again. As 38 CFR 3.957, and that has to do with protections for service connection.
Thank you.
And essentially, and I'll give an example after this. So essentially what it means is that any condition or DIC, a death benefit, that's been in effect for 10 years or more will not be severed unless there's evidence of fraud, or is clearly shown from records that the person didn't have the service or character of discharge to receive such benefit. And basically what that means is, and I'm going to give you an example. And the reason I brought up the appeals part, I kind of wanted to stay there. Before they started having higher level reviews, they also have the older appeals. And this has come up before. If I make a decision today, I'm going to explain it just like this. If I made a decision today to grant hearing loss, but I realized that that condition, even, should have been granted 10 years ago. So I give an effective date of going back 10 years. Guess what? Now that condition for service connection purposes is protected. Does that make sense? So that's what you would be looking for. So service connection is protected if it's been in effect for more than 10 years and there's no evidence of fraud. So no one should be able to tell you they're going to sever service connection for a condition, even if it was an error. So we have had claims like this, and I've had to write people up for it. But the reason is, so let's just say you came in for a right knee condition, and they granted service connection for a right knee and a left knee for some reason, because the exam said so. If that left knee condition really is not service related, but it's been service connected for 10 years or more, then it's service connected, because there was no evidence of fraud on the veteran's part, and your service is honorable, it's protected. Does that kind of make sense?
Yes.
Any questions to that?
Yeah, hello, Mr. Horton, you're on mute. If you got a question, go ahead and unmute, sir.
Okay.
Yes, no?
There you go.
Yes, I have a question.
Mhm.
You've had a condition for more than 10 years and you had a increase on said condition. Does the service connection date change?
Okay, so I'm going to get to evaluation after we clear this part up, but your service here, if it's been in effect for more than 10 years. Now you're talking about evaluation, which is the next regulation we'll discuss. So how about I just transition into it and we'll talk about evaluation. Okay.
Hold on, Betty, let's get a
Is
clarification
that
on
okay
this
with
question.
everybody?
Hold on, Betty. Let's get a clarification on Mr. Horton's question.
Do you want me to say?
Yeah, hold on one second, Betty. Mr. Horton, are you saying if you're service connected for a condition and you come in for an increase, and say for instance 10% for the knee, right knee, and that 10% has been in effect for 10 years, are you asking if you come in after 10 years and you get an increase to 20 years, increase to 20%, is that 20% still protected under that 10-year rule? Is that your question? Or does
Yes.
it 10 years start over when you get that increase to 20%?
Right. Yes, that's the question. Yes.
Okay.
If it just starts over when you get an increase.
Right. So
Okay,
do you,
so-
you understand that, Betty?
I do. No, I
Okay.
understood. No,
Okay.
that's why I said we would talk about it in the next regulation part.
Okay.
That covers actually his question. But no, thank you for clarifying for me.
Okay.
Okay.
All right.
Okay, hold on 1 second. Okay, so the next regulation I'm going to talk about is 38 CFR 3.951. And that discusses preservation of disability ratings. Now, there's two parts to this. So what I'm going to do is, Mr. Horton, to directly address your question, I'm going to kind of go out of order because there's a part A to that and a part B, okay? So for the part B, if you have an evaluation that has been rated, let's say, for, I'm going to use your knee example if that's okay with you. If your knee has been rated for 10% for more than 20 years, and let's just say you come in for an increase and it actually has improved, okay? if it has improved, but it's been rated at 10% for more than 20 years, then it cannot be reduced, period. Or in your case, if you were service connected in the beginning, let's say 1982, and you come in for an increase and you were rated at 20% since 1982, well, it's going to be protected because it's been in effect for more than 20 years. So even if it's improved like to the 10% level, they can't take it away from you because it's been in effect for 20 years. Does that make sense?
Yes.
Okay.
Yes,
I mean, and if you want me to break it down, I can. Okay. I just want to make sure. I'm not being funny, guys, when I start saying things. And Dwayne will tell you this. I have had raters who struggle with some of these things. And so I'm not being funny, you know. So if you need me to break it down some more, I'll try to break it down as much as I can.
And let me tell everybody,
Does that make sense to everybody, though?
when I would ask her questions, when I say a true walking dictionary, and if I wasn't getting it, I'll tell you what she tell me. Boy, if you don't get off my phone and go look these regulations up, okay? So when she's quoting these regulations, make sure you write them down and do your research because she's giving you very important information. Okay, I'm sorry, Betty, go ahead.
So, not to
Thank
interrupt.
you, Mr. Campbell, I think.
So,
Oh, no, go ahead.
so for protection of your service connection is 10 years or more. For preservation is 20 years or more. Is that
right? For a disability that's been right. So when you hear somebody say the 10-year rule and the 20-year rule, that's what they're talking about. One has to do with service connection. The other one is completely related to evaluation. Now, there's another part of this regulation I want to discuss, but I want to make sure, because this one probably comes up more. But since VA has been doing a lot of changes to the rating schedule, the Part A is actually cropping up more than it used to. So I do want to talk about that part, but I wanted to make sure everybody got the part. If your condition has been rated for 20 years or more, then it's protected. So, okay, I don't see, look, I can't see if y'all raise your hand or anything. So
I'll let you know. Yeah, okay, I'm monitoring. So she can't see you guys. So if you have a question, just everybody's on mute. Just raise your hand and I'll tell you to go ahead and unmute and we go from there.
Okay, so the other part of this regulation that I was discussing, and it's the same 3.951, but it's Part A. Okay, the one we just talked about was Part B. This is Part A. And basically, and I'm going to read it just like it is, and then I'll explain it. So it says a readjustment to the rating schedule for rating disabilities shall not be grounds for a reduction of disability rating that was in effect on the date that the rating schedule changed, unless there's medical evidence that shows that the disability has actually improved. And this is where the confusion comes in a lot of times. So I'm going to explain one. I'm going to use the older one just because it's easier. Because like I said, the rating schedule has changed a lot just recently. But back in the day, when we evaluated back conditions, it was using different criteria than they use currently. Okay. And because of that, so if you came in, you had a back condition, I'm gonna say again, 1982, that's when I graduated, y'all. So that's why I keep using that. But 1982, if you had a service-connected back condition, and it was evaluated under the criteria that was in effect at that time, if you come in 3 weeks ago and ask for an increase, and let's just say based upon the current rating schedule, your back condition has improved, they can't reduce you because your back condition was evaluated under the criteria that was in effect in 1982. And I can assure you that none of the criteria that we have now, it reflects anything that was in effect for 1982. So they couldn't reduce you. And it has happened. They'll make a mistake sometimes and do it. And that's when you need to either call them on the carpet, look, or it might not even get processed because it might get caught by someone else. Okay. So now any questions about what I'm saying? Because I want to make sure that it's clear.
Nope, we don't have any questions, Betty.
Okay, I just want to make sure. Okay. Oh, wait a minute. Y'all making my job too easy. No, I'm just teasing. Okay, so this one, okay, these are actual protection rules. But Dwayne wanted me to talk about them because they do occur, because a lot of people are interested in it. The one I was going to talk about has to do with 38 CFR. And I believe you said, Dwayne, that you may have had some questions with this one that's coming up. It has to do with 38 CFR 3.344. And that is stabilization of disability evaluations.
Yes.
And essentially what this means, because it's a very long regulation, but essentially what it means is that any rating that was in effect and is considered static, I'll say it that way, should not be reduced on one evaluation. They should be looking at it, making sure that it actually has improved. There is another regulation, I thought I put it down, but I guess I didn't, that also talks about that. Hold on, I'm gonna pull it up. 1 second, guys. Because they kind of go hand in hand, if that makes sense.
You still there, Betty?
I'm here. I'm just
Okay.
having computer issues. Look, I told you,
Okay.
I was having a few computer
Right.
issues. I'm trying to
So-
get to it.
Right. So what I was asking Betty to cover, and I get this question a lot, or I've even talked about it, is when you're service connected, when you have a percentage for something, and a lot of veterans, if that percentage is been in effect less than 5 years, and you come in for an increase, and you go to the exam and it shows improvement, okay, then you could be reduced. Now, if that's been more than 5 years, and that exam shows improvement, but she just stated they need more evidence or another exam for something to show improvement. And that's one of the things why I tell people, you want to get a copy of, I challenge people getting a copy of their claims folder, because in there, you'll have that rating code sheet. And on that rating code sheet, it'll give the diagnosis, the effective date for that particular percentage. So to what Mr. Horton was asking earlier, if you're 10%, it'll have an effective date. And then you can see, okay, if you increase, you can say, okay, has it been in effect 10 years or less than 10 years? All that information is on the rating code sheet. And that's something we as veterans don't get. We get the rating decision, but we don't get that rating code sheet. But if you submit the FOIA request for your claims folder, you would have that rating code sheet. Okay. I'm sorry, Betty, go ahead.
Oh, no, you were fine. No, I was, like I said, I was trying to get all the stuff. I wanted to make sure I had gotten it all. Okay, so the other part, so examinations are also covered in 38 CFR re-examinations and 38 CFR 3.327. And that discusses when you should be scheduled for an exam, because sometimes we mistakenly schedule people for things that are rated, let's say 10%. So in the knee example I gave, if it's rated at 10%, that's the minimum evaluation, and they should not be scheduling you for a future examination. So that's one of those things you need to know. So if they do that, then you need to call them on the carpet. Okay? Does that make sense?
They're shaking their head. Yep, they got it.
Okay, all right. I was trying to make sure I had covered, because it has a few parts in it, but I wanted to make sure that makes sense. So basically, if you have something that is been rated for 5 years or more, and then it's kind of considered static. And so I'm trying to think of something. Let's just say arthritis, and of a knee, 20%, it's been rated that way for 5 years or more. They get an exam, even if you file an increase. Let's just say you want to come in for a 30%. If the exam shows that that condition has improved, they should not, I will address you in just a second, Brent. I saw it. They should not reduce you right then off of that examination. What should occur is they should schedule for a future examination to determine if sustained improvement has been met. Does that make sense?
They're shaking their head. Yes, they understand.
Okay. All right. So when I say call them on the carpet, send them, you have to reach out to the VA and tell them, hey, look, this regulation says this. Look, I read it. This is what it says. Y'all didn't do the right thing. Plain and simple. That's calling them on the carpet. But just know your facts and let them know. Does that make sense when I say calling them on the carpet? I mean, in the beginning, that's what you're going to do because actually they've made a mistake.
And when they make that mistake, how does a veteran know that they made that mistake, Betty? If they don't have their claims folder, how do they know that the VA made a mistake?
Well, just like we were saying, so one of the things, I mean, you can request a copy of that decision completely. That will include the code sheet. Also, just like we're having this discussion, you have to educate yourself on the various references that cover your particular situation because everybody's situation can be different. Does that make sense?
Hold on a second, Betty. We got a question in the chat. Let me get here. Brenda said, okay, okay.
No, I got it.
Okay.
I saw it. It popped up. Okay. So, and I was able to catch it. Let's just say, if you know that and this is what we call, I just didn't want to get too far in depth with that, but it would be what we would call a clear and unmistakable error. If you call a clear and unmistakable error on a decision that VA has issued, then you can submit it on anything. So there's no particular form for that particular issue. I suggest using VA Form 21-4138 only because it's easier to clarify and recognize, but you don't have to submit a particular type of form for a clear and unmistakable error. Technically, you could send in a letter. And it's still, but you want to make sure that they know that you're calling a clear and unmistakable error on the decision, and then identify what you believe the error is. And that's why you have to know the regulations. Does that help?
Yeah. We got a question from Mr. Horton. Mr. Horton, go ahead and unmute your mic and ask a question.
Well, it's more of a statement. It's the other day. If you want your code sheet, I did it the other day. I called up my local VA regional office and I had them email it to me. I had them email the decision letter from November 8th, and I had them email me my rating code sheet, and I had it within 5 minutes.
Perfect. That's a great example. Thank you.
You're welcome.
Any other questions on that? Does anybody have any other questions on that? Okay. Well, Betty, I got a question. Yeah, I got a. Oh, were you done explaining? Because I did have a question, but go ahead.
Oh, that part. Yeah. No. I was gonna.
Okay. So the question I have, Betty, and we've talked about this before. There's this huge myth out there on YouTube, and with your 35 plus years of VA experience, I think you would be the person that. Okay.
Dwayne.
Yes.
Hold on, before we get there, seriously, because that is in my my second term, my last part. I'm looking at the questions that I received from you.
Okay.
So I haven't forgotten, but I did want to talk about one thing about continuation of total disability ratings, and that's covered under 38 CFR 3.43. And it talks about reductions in the general process, which also has to do with your question, Dwayne, total disability ratings when warranted by the severity of a condition and not due to hospitalization or other factors will not be reduced in the absence of clear error without examination showing material improvement. And that's one of the keys that happens often. So if the person doesn't come in for it, they should not be reducing it. Also, that particular section, and I'm going to skip tuberculosis because that doesn't happen very much, but it talks about IU, aka individual unemployability. And why that's important is because no condition, let's just say if it's a mental disability, because that's just one that you could get, and I'm rated 70%, and I'm getting IU for that. There has to be clear evidence showing that I can work now due to my mental disability, and not just because, and when I say this, it has to show that there was marked improvement in that condition before they try to take away your IU. And I did not say this, but just so you'll know, IU is also protected under the protection rules that I talked about earlier. So just so you'll know, there's a certain, if it's been in effect for more than 20 years, a death, whatever, it's protected. Okay, I did forget that. Let's see what else I want to say before I move on. Also, you have to look at, let's just say you do get a job. Okay. If you're not gainfully employed, and what does that mean? Gainfully employed means they use the index set by what's their names? The government. Come on, help me, Dwayne. Look.
With the Congress, the poverty level.
Yes, that's what I'm thinking. Poverty level threshold. Okay. Yeah. They set it each year. And so if you have not made more than that, even if you're working, they can't take away your IU. And if you make more than that, they have to wait at least 12 months showing that you had gainful employment. So that's like a protection too. So they can't reduce you just because you started working. And they have to see if you're successful in that work, that you're able to make a living wage based upon the poverty threshold. Not based upon bed, because I might not agree with what they pick, but but based upon the poverty threshold, they should not reduce you if you're receiving unemployability benefits from VA. Does that make sense to everybody? So that's sort of like another protection. So that's something that you have to pay attention to if you're receiving IU. Yes, no, everybody good?
Yeah, they're saying shaking their head.
Okay, all right. Thank you, everybody. I'm just making sure. And so the last thing, I know Dwayne wanted me to bring this up. Well, I have an example of it. It's not going to be
But can we read the question first, Betty, so they'll understand when you start explaining it?
Of course.
But yeah, because this is a question that I see a lot. And we'll get back to your question, Brenda, about, she's saying what's IU. We'll get back to that in a second. But I'm going to read the question, and then you could go ahead with the examples, because this is something that's out there on YouTube, and a lot of veterans, it makes them nervous. They're saying VSOs are telling them, and other people are telling this on YouTube. So the question is, if a veteran is 100% permanent and total, and a veteran comes in for a new claim, will the VSR go back and look at everything he or she is service connected for?
Okay. Yes, we had this discussion, and I'm going to say, I'll give an example to help clarify it. But so let's just say you have a heart condition that is rated 100%, okay? And it's been determined that it shouldn't improve, okay? If that's the case, then if you come in with a right knee condition, asking for a new service connection, they should not look at your heart condition, if that makes sense to everybody, okay? So there's no reason why you couldn't file a claim for your knee condition, because your heart condition should not be being looked at. Now, I like to say never, okay? So I'm going to give you an example where potentially it could happen, where it could end up getting reduced, And this has happened, so I don't want you to think it can never happen. So I'm not trying to scare you. You should always file for what you believe that you're entitled to. Okay, so I'm never going to tell you not to file for what you think you need, what you believe that you're deserving of. Okay, so for instance, in the example I gave, if you have a 100% heart condition, you come in for a right knee condition, but your doctor happens to submit records that have to do with your heart condition, and your heart condition, let's just like I said, has been rated less than 5 years at that 100% level, even though we determined that you were permanently and totally disabled. If some of that medical evidence that comes in there shows that it has improved and that your heart condition actually got better, in that instance, VA is obligated to address it. But otherwise, no, nobody should, just because you submit a claim for a right knee, they should not schedule you for a heart examination because you didn't ask a claim for it. We didn't have any medical evidence or reason to schedule an examination for it, and actually it would be an error to do so. So no rater wants to take on trying to get an error. So no, they should not routinely schedule you, like I said, for examinations because you come in for a new condition, or even if you were service connected for that right knee and you come in for an increase, if that's all you're asking for, that's all you should get. Does that make sense?
So we all understand if you're 100% PNT, she just explained it about, because there's a lot of information out there on YouTube saying that, oh, if you're 100% PNT, you file a claim for something, they're going to go back and look at everything. And she just explained it. So she debunked that. Okay. Okay.
Are there any other questions? Maybe I know you had one.
Yeah, Mr. Bonita, how you pronounce your last name, sir? Bonelia?
Yeah, I've been called many names, but it's all right. You could call me James.
Okay.
I don't know if you want to answer the IU first, because that's, you know.
Okay, that's what I was going to ask. Okay. What was the question about IU?
She asked, let me pull up better. She said, sorry, but I missed it. What is IU?
Oh, okay. I didn't go into depth about what it is, but basically, IU, better known as individual unemployability. And basically, that is when your service-connected conditions are evaluated at a certain level. And I'm not going to get in depth with it, but is evaluated at a certain level that makes you entitled to that benefit for IU. And basically, it's like, I'll use the mental condition I had said I have. So if I'm 70% for a mental condition and I feel I can't work, or I've been trying to work and I had to stop or whatever else because my mental condition affected my ability to obtain a job or keep my job. And I say that, so let's just say I know that I have some things going on and it's affecting how I can work or I can't work or whatever else. You can potentially get what we call IU, or individual unemployability, if the evidence shows that I can't work due to my service-connected disability. And that allows me to receive VA benefits at the 100% rate, even though my service-connected disability is only evaluated at 70%. Does that make sense now? Oh, no problem. Anybody else got questions about what I just said there?
No.
Oh, Dwayne, you're on mute.
Go ahead, James.
Yeah, I'm new to the claim process, 2 years in, even though I've been out since 1997. 2 years ago, I decided to go to the VA, and I was diagnosed with PTSD by the doctor, the VA doctor, psychologist. And I've been getting treated up to date for PTSD. And a couple of months after I was diagnosed, 2019, I put it for a claim. At the time, the VA rater, and I wasn't really educated like I am now, thanks to Mr. Kimball, rated me as other stressor related to combat, which I was in Desert Storm, and basically said I didn't have PTSD. So they basically went with the CMP examiner. They went off of that instead of going off of the VA psychologist. Not knowing, I was at the time, and not knowing, I was happy, 30%, woo. And then finally I put in for an increase because I was like, what is that other stressor? And they kept on saying, well, mental health is all the same. Don't worry about it. And then I said, well, let me put in for an increase because I feel, my mental health it's gotten worse. So I just recently put in for the increase about a month or two, and everything went quick. But then they sent me to a second CP exam, and they said, we need clarification because you're saying you have PTSD. Your doctor's saying you have PTSD, but your claim is for other stressor, related disorder, whatever that means. And nevertheless, they came back with a favorable decision, but they wind up changing my mental health to PTSD and gave me 70%, which I'm happy. But the whole point is, do I have elected stay on to go back to 2 years ago and say, hey, are you the VA rater? I don't know, or just be happy with my decision and life goes on.
Okay, so without me, I wasn't going to ask you what your condition was, but let me just say this. Without me or someone else looking at your file,
okay,
to see if the prior decision was incorrect, because the VA is allowed to change diagnosis as long as, the situation is similar, et cetera, et cetera. So a mental disability, although I might feel like, hey, they called it other, and I wanted to be named this. Yeah, I understand what whoever was helping with your claim, but whether the evaluation is correct, effective date, or anything else, you would actually need to get a copy of your claims folder and review it and ensure that there were no errors in the decision. Otherwise, that decision stands, if that makes sense. And I hope I didn't talk out of turn, Dwayne.
No, you didn't. You're good. You're good.
Okay. All right. So, I hope does that help?
Yeah, and also I have when I put in, they also granted me for migraines. I put that as a supplemental claim, and I told that to Mr. Kimball yesterday at the YouTube, and he says, and I said they changed it to HLR decision. I was confused because I submitted a supplemental claim, clearly the form with the VSO. I have a copy of that. Why would they say HLR decision? Do they trying to avoid back pay? Because, but or they.
Okay, I'm sorry. I don't mean to cut you off, but
Yeah,
because it's very personalized, like I said,
okay.
Without me being able to see the folder, and I'm sure that you've been talking to Mr. Kimball about what's going on with your particular situation.
Okay.
I don't want to say because I don't know. And that's why I try to tell everybody, and I know Dwayne knows this as well. When I've had discussions on various claims, when he had a question or whatever else, it all depends on what's in your folder. I try to explain this to other people as, let's just say you go to court for something, okay? Y'all, two different courtrooms, two different judges, same kind of evidence, but you have two different lawyers involved and everything else. One court may rule one way, the other court may rule the other way. So because they may look at your evidence differently, or they may see something in claimant A's folder that looks different than claimant B's, that requires them to make different decisions. So I never try to say, oh, I'm gonna tell you, and well, Dwayne knows, and I told many raters, I need to see the folder. Don't just call me up and ask me a question, because I'm going based upon what you say, but you may be missing an element in that folder that changes one person's decision to another person's, if that makes sense.
Yeah, thank you for answering that. Appreciate it.
Okay.
And I couldn't answer it last night because I was assuming, and correct me, James, if I'm wrong, it was a supplemental, and then automatically it changed to a high-level review. So you submitted an 0995, and then for some reason they said, oh no, it's a 0996 high-level review. I never seen the VA somebody make that jump. It's normally the veteran saying, they're claim, they're doing a high level review. They want an informal conference or something like that.
Yeah, I'm sorry to make it personal, but I look at it as an educational tool. I'm probably just going to be satisfied with my decision, but if any veterans that I know, that I can educate, just like what Mr. Kimball does, it's all about trying to help other veterans. So, I apologize for making it personal, but
Oh, no,
you're
that's
fine.
not it. No, your question help. It's just sometimes I don't like everybody to put their stuff out there because it's not just the people on the Zoom call right now. As he said, he's recording it, and it may be something that you don't want someone else to know. That's all I'm saying.
Yeah.
Okay.
Thank you.
But as long as you got your question answered, I'm happy.
Thank you.
You're welcome. Are there any other questions based upon today's Zoom meeting that I have not addressed?
I got one, Betty, and this is sort of off the topic, but it's one that I get asked a lot, and I know you.
I'm not going to answer it. No, I'm just
But it pertains to
Yes,
these
sir.
it pertains to these DBQs. And as of March 1st of this year, veterans are now allowed to get DBQs done by private doctors by video.
Mhm.
But what a lot of veterans
Correct.
and some of my clients are encountering, they'll go out and get a DBQ and or nexus statement. And I always tell people, make sure you become educated on them both, because you need to know when they're needed and if they're actionable and sufficient. If they're submitting these to the VA and the raters, they're submitting them and they're actionable, meaning that the adjudicator, the rater can use them. So what a lot of veterans have seen, what they're seeing is they submit a DBQ for increase or secondary service connection, whatever, and the VA can use that information, but the VSR is scheduling a CMP exam. And then the veteran is notified and they're like, oh, wait a minute. You all have information that I submitted for my private doctor to use, and you're not using it. And the VA employees are not telling them why. The question is, it's up to the veteran to make this decision, but can the veteran refuse that CMP exam that has been requested and say, please rate with the evidence that I've sent you that is actionable and sufficient? Can the veteran refuse the exam based on those bases?
Okay. So my suggestion, and I'll say it this way. If you submit evidence, and that is a regulation, I don't have it pulled up right now. I'm sorry, guys. But if you submit evidence, and it's always been this, so it doesn't have to just do with DBQs. It's always been this way. If you submit medical evidence that is covered, that covers your disability and fits the criteria in the rating schedule for your particular disability. And that's why you have to kind of educate yourself on your particular case. But if you submit that evidence, instead of saying, I refuse, you can say, for clarification purposes, I'm not understanding why I'm being asked to report for an examination when I submitted medical evidence that supports the criteria shown for a full and complete examination of my disability. And when I'm saying that, that means because sometimes, people get their feelings, and it's not right or wrong, but it's wrong. But and Dwayne knows I say it. Look, because there's a regulation that covers attitude of the raters too. So we got a whole bunch of regulations. Not being funny, but it's not just for veterans. Look, they cover how we act when we make a decision. So you can always ask, how come I'm being asked for this examination? Call in and ask a question because I'm confused. I submitted something, not sure why it's insufficient. Does that make sense? So that way you're not saying that I refuse, or if you say I don't want to go because of those factors, explain why you don't want to go. I mean, that's always key, because even if they make the wrong decision, you always have another bite at the apple through various processes. And so you want to have it documented, shown that you was like, I don't understand what's going on. I gave y'all this. What's wrong with it? Does that make sense?
Well, I did what you said not to do. I told him, I said, I'm refusing, I'm not going, and you need to rate with the evidence of record. That was just me. That was just me. I am. I was just like,
yes.
but I get I do get what you're saying, but I just wanted people to understand that, because that's something that's been happening to veterans here recently, and then they get confused. They get confused on, why is this happening when I went out and had my doctor do it, and they don't understand why the VA is not using that information.
Correct. I mean, the law says that any evidence, whether it comes from VA or a private care physician or the VA hospital, outside, outpatient clinic, if those examination reports are sufficient as anything you can get from a VA examination, they should not be scheduling an exam.
There it is.
But you have to remember, and this is the problem. I will say one more thing. They potentially have people looking at claims based on how their process is set up, who may not have the requisite skills to make
Training.
such examination. And that's right. I'm like, and so they should be potentially going to ask somebody a question, but I just say, if they ask you something that you feel is incorrect, go out and ask why. I mean, why y'all doing this? Because I don't understand. I mean, that's my suggestion.
Right.
That's my personal suggestion.
Right. And when they tell you why, ask what regulation they're getting from. What M21 or 38 CFR are you referencing that, so I can have it for my records? And a lot of veterans,
always ask why it's insufficient.
Right.
So that's the key. That's why my evidence is insufficient. Because in the interim, even if they end up making a decision, if you decided not to go, then they're going to have to definitely address why it was insufficient. Not just making it up, but they got to tell you why it was insufficient.
Right. And in some rating decisions, especially with some clients of ours, they're not telling them what makes their DBQ insufficient. They're just saying, "Oh, I just don't feel comfortable," and that's not a reason.
Well, that's not a regulation. I said that's not a regulation.
Exactly.
Not a regulation.
Right. But they're saying that, and they're just, they're rolling with it.
No,
and
and that's when you have to take the next step, Dwayne. I mean,
right. I agree.
I mean, that's it in a nutshell.
Right.
They're not doing what you.
Brenda had a question. She says, when is age a factor regarding reduction of a rating decision or re-examination?
Okay, so that's covered under 38 CFR 3.327.
See how she just routed that off? I told y'all she was a walk-in VA dictionary. I'd have had to go look it up.
I'm trying not to be. I've been tired for a little bit. No.
I told you. See how she just routed that off? I would have had to go look it up. See, I can't. My years can't even scratch the surface to her years. Oh, sorry.
Hold on. Wait a minute. Hold on. Did he just call? Wait a minute. Hold on. I will say it again. But did he just call me old, y'all? Okay.
No, I said my VA years of service can't even come close to scratching your VA years of service. That's what I was saying.
All I heard was old. Anyway, it's 38 CFR 3.327. And this isn't a protection, but it does discuss re-examinations. And there are times when VA should not schedule a re-examination, and that includes, unless there's some really significant evidence. That's why I said there's always a caveat. Don't think I'm saying this is always, the rule of the land, but VA should not schedule re-examinations. And I'm just going to throw a few out there. If you're rated 10% for a condition, okay. If you are 55 years or older, and that re-examination would occur after that time. I'm trying to think of what else. Unless for a unique situation. That's why I said you have to look at it.
If the doctor notes that your condition is considered permanent. So if you have a DBQ completed and that doctor notes in that DBQ that your disability is, if it's mental, if it's guarded, or any other condition is permanent in nature, they're not supposed to schedule. Yeah.
Word is static.
Right.
Okay, hold on. Let me just pull it up. Can y'all hold on 1 second?
And for everybody, I did a YouTube video on that. I think it was last year, and I pulled up the M21 reference that gives these bullet comments that Betty's talking about, and it's called routine future exams. So if you go to my YouTube channel and type in routine future exams, that video should come up, and Even though it's the M21 down below, it'll give you the 38 CFR, but it's the same information.
Hello. Somebody tried to call me. I missed something you said, Dwayne.
No, I was saying I did a YouTube video and I talked about the M21 that covers those bullet comments that you're going over.
Okay.
So just in case
So
if they
okay. Oh no problem. I just wanted to make sure.
no, go ahead.
Look,
Go ahead.
it's just
But
that
if you pulled it up, go
I
ahead.
forgot to put it on Do Not Disturb.
No, if you pull
I have it up.
okay, if you pull it up, go ahead and cover it. Yeah, go ahead.
Yes, sir. So it's 38, like I said, CFR 3.327 reexaminations. And it talks, there's a general paragraph, but I'm going to get specific for compensation claims. So it's Part B, Section 2, and it talks about no periodic future examinations will be requested. In service-connected cases, no periodic reexamination will be scheduled when the disability is shown as static. And then it goes through II through all the way through 6. So, and I want to say they might even have a second, but anywho, they have in there, and that was your question, you said. So for, if you know Roman numerals, 4, in cases of veterans over 55 years of age, except under unusual circumstances. So that's why I say there can't always be a caveat. But normally, no, they should not schedule for a future. If you have a heart condition, you're 55, it looked like maybe it might have had improved, but they're not sure, they should not schedule for an examination unless they knew for sure there was some kind of unusual evidence in your record that it was going to improve.
What about cancer?
Cancer is not covered under that because cancer is up under. Are you trying to nod me like I didn't know?
No, I'm saying you're right. No, I'm saying you're right. You're right. I'm agreeing with you.
That's one of the unusual circumstances. So with cancer, the rating schedule is set for that wherever the condition is shown to be the cancer, whatever site where the cancer is, there is a rating schedule criteria that has to be met for any evaluation that's put into effect. Okay. So, I mean, because there are different time limits and those kind of things, I don't want to go into depth about disabilities, but hopefully that makes sense. Did that help the question?
Yeah, shaking the head. Yeah. Mr. Horton, you had your hand up a few minutes ago, a couple seconds ago. You got a question?
Well, it's a little off topic. And I wanted to see if she or you, either one, could answer the question. I was just recently denied for a claim for not that for the VA not being able to find out if I was actually in the Southwest Asia area during a presumptive time frame for the conditions that I was denied for. And I was wondering, this is something that I'm working on right now to do a supplemental on to give them the information they requested. But what I don't understand is why didn't they have the information? I'm getting the information from them to give back to them, basically, where I was, where I was at, so I can be service connected for these conditions.
I could say this, and I'll just, I claimed flat feet as pre-service aggravation. I didn't get an exam for it. I was denied. In that denial, it stated, we do not see treatment in your records. So I requested a copy of my medical records. On the first page, on my entrance exam on active duty, there it is, moderate pest planners. 3 or 4 times throughout my military service, I went on sick call for bilateral foot pain. Now in the rating decision, they say they can't see it. So and they said they looked at these documents, okay? But in the rating decision, they're saying they looked at these documents, but they didn't see anything. So they sent me, I requested those documents that they reviewed, and I looked at them and the information was there. So I can't say why that happened. Maybe they were just top sheeting it. Maybe they didn't look at the evidence at all and said that they did. But think about this, there is a human factor.
Right.
There's people looking at this and they miss stuff. A lot of times I got a copy of my claims folder and I show this. This is what mine looks like. This is what a claim folder used to look like at the VA. Now it's
It looks
electronic.
like mine.
Right. And if I was still rating, I would not think this would be a lot of information. I've seen these are 2 binders. I've seen these go up to 20 and people had to push these around on a cart. Okay. So keep that in mind and tell people keep that in mind. This is where the human factor comes in. It could have been missed. In your case,
I
Mr. Hort.
actually,
Go
oh,
ahead,
I was
Ben.
just going to say, just so you know, just from a little experience, I actually had to review a claim back many years, and there were literally 21 volumes that they looking like Dwayne's that they put on my desk and like, oh, can you hurry up and look at this? Huh? Look, I'm like, wait, hold on, look, wait a minute, I got production requirements. You want? I mean, I did it. I did it. I looked at it. It took me days, but I got it.
Mhm.
Look, the veteran was happy. I was happy, but maybe my coach wasn't happy. But they gave me that folder. I looked at it. But sometimes you, we get volumes like that, and actually the electronic version sometimes is worse
Yeah.
because it's harder to review. It's harder to scroll through. I could look through things and tab it easier and whatever else. So that's just not an excuse, but just it could be that they could have just missed it. But it's always good to have a copy of your own file. I tell
There it
everybody
is.
that. Get your own copy.
And
If you
what
can
I've been
get a
telling
copy before
everybody,
you come out of military, look, get a copy before you come out the military so they don't lose it.
if
in
you come on my
transition.
live stream every week, when people ask me questions, what is the questions that I ask them? I go right back.
Where's your claims file? You
Yep.
have it.
Yep.
When are you going to get it?
There you go.
Yes,
I-
yes, sir.
I always ask that question. See, so she's telling you, and when she was talking about it, she's telling you, hey, when you're doing this, it's in your claims file, you know. But yeah, I don't want to take up time. If anybody got questions, like I say, we got 35 plus years here, walking VA dictionary. So go ahead and ask away. I don't want to take up anybody's question.
Thank you all, though.
You're welcome. You know, you all
You're
are quiet. I normally get hit with a bunch of questions all the time. They
You
got
must
30.
not be as hold on.
You
You
know,
must not be as effective as I am.
Okay. We going there, huh? Okay.
No, I'm teasing. No, my brother.
I know.
You saying that the VA doesn't recognize you were in Persian Gulf? Is that on your DD-214? Is that what you're saying?
Yeah, it seems like they would have that information, and I'm going to have to spoon feed it to them a little. You know, I'm gathering information right now. I'm going to do a supplemental and give them everything that they were requesting that I figured they would have themselves. I was actually told, oh, don't worry about it. They've got that information. They're just asking just out of, habit. And when I did, I got, they denied it because of that. So I learned a lesson.
Yeah, I don't know you have to, but I did the Gulf War registry. I'm not saying you have to because it's time consuming. But ever since I did that, they always send me, emails and with the burn pit as well.
Right.
But I'm just saying that just takes time. I mean, obviously you want to, do your claim, but that's a no-brainer. It's on your DD-214,
Right. Well, they asked me the same thing if I went to the registry. Well, I actually asked my local hospital twice. They never scheduled me an appointment. So I just gave up on that. And that was like 10 years ago. And I guess maybe I should have pursued that, but I didn't know I was ever going to be in a position where it benefited me,
We got any other questions? Man, they quiet. Y'all gonna make me ask a question? So, real quick, Betty, a lot of veterans, they think they'll say, oh, go ahead and unmute your mic, Lawanda, and go ahead and ask your question.
All right. Hey, everybody.
I
I just wanted to find out if with a higher level review, it's showing that a error was identified and it's not showing what the error is. Is it a way that I can find out what that error is that has to be corrected before they can uh, close my claim? Is there any
okay.
way to find out?
I mean, other than calling, um, so and it depends. The higher level review process is a little bit convoluted to me, at least to me. I'll say it that way. And the thing is, if they've shown that there was like, I'll say a duty to assist error in which they failed to properly ensure they had all the evidence required or something like that before they make a decision, which is covered under, and I'm just going to get a regulation, it's 38 CFR 3.159. And that actually governs all of our actions that should be covered under VA's duty to assist, okay, in how we get evidence, make a decision, all that kind of stuff. If it's determined that it's a duty to assist error, then it's going to get kicked back from the higher level review process for someone else to do that decision. If they're saying that it's, and there's only, and I don't quote me right now because I would have to look it up. The higher level review process, and they just need one thing, then you might be they're going to make that decision. But if normally most of the errors that are identified during a higher level review are related to duty to assist errors, if that helps. But without me seeing your folder, or I mean, I don't know when you came in on the call, but without somebody seeing your folder, it's hard to just say what it is. But you can always reach out and ask what it is. Does that help?
Yes, it does.
Okay.
Thank you.
The other thing, Betty, a lot of veterans, they'll ask me, they'll say, hey, I got service connected for a back condition at 20%. And they feel that they should be at 40%.
Mm-hmm.
And they'll say, well, I'm going to do a supplemental claim. Is that the right route if you disagree? You got the service connection, but is that the route or the process is to turn around and file a supplemental claim because you feel you got the incorrect percentage for that condition, service connected condition?
Okay, I'm gonna have to answer that question with what I just said. My suggestion again is always to have not just a copy of your file, but any evidence VA relied upon to issue a decision, and look at the rating schedule. And if you know that you met that particular criteria for the increase, let me just say it that way, then there are different choices that you can make. I can't tell you what those choices are. Okay. And I'm going to say it just like that. And I'm not going to use VA as an example. I also was the president of my local union. And when I had to make some tough calls to help people, sometimes I had to say, okay, the agency is giving you 3 options. I can't tell you what's going to be best for your household. You're going to have to look at your options and then see what's best, because each one can have consequences. And so I can't say in that case, Dwayne, that you just, that example, what's best. So you have to look at, was it clearly and unmistakably an error?
Well, no,
So,
I'm not saying what's best, but let me rephrase the question.
okay.
Define a supplement. What is a supplemental claim?
Oh, wow, really?
Yeah.
He just cut me off. Woman.
Oh, I'm sorry.
No.
See,
Oh my
everyone,
God.
we have this type of relationship. This is how conversations go.
So we
When
having a conversation on Zoom? No. Okay,
no,
guys. Okay. Oh my gosh. Look, I am
no.
so sorry.
So can you?
I'm
No,
like, what?
no. I'm saying, can you define? I'll say, let me phrase the question. Can you define what is a supplemental claim?
Okay, so let me say it this way. The impact, I'll say it this way. The impact of a supplemental claim is, unless the rater determines that there's an error then it might affect your effective date, even if they grant the benefit. So I can't say, Dwayne, it is that initial, what they call the appeals process now. But
Now, what I'm getting at is when you file a VA form 20-0995. So
Mhm.
if I was denied service connection for a back,
Mhm.
I'm going to submit that on the 0995 with new and relevant evidence as a supplemental claim, correct?
Correct.
Yeah, that's what I was getting at.
Okay, so with the new and relevant evidence, so it still is the same thing. They have to go back and look at the prior decision and see if there was a connection from your current supplemental claim to your initial claim.
Right.
And if there was, and if it's grantable, then the effective date will probably reflect what you originally put in. But they can also look at it, and that's why I said it's convoluted, and you caught me off guard just because to explain it. Technically, they could grant it from the date of the supplemental claim.
Right.
So that's where the problem is, because it depends on what type of evidence you submit with your supplemental claim. Higher level reviews, you can't submit any new evidence that was not previously considered. So that's one of the standouts for that. And so if you submit new evidence, then they're going to kick it down to a supplemental claim because now you've submitted additional evidence. Okay. So, I mean, I hope that makes sense to everybody.
Oh, yeah. Yeah.
Okay.
And
Hold on, you said, oh, yeah, I'm asking everybody else.
no, they're shaking their head. I'm agreeing with it.
Okay, I can see. Thank you.
Okay, yeah. Because that's been the confusion that veterans have either when I'm talking to them in my live streams or
Mhm.
reading comments on some of my YouTube videos. You know, they're unclear on
The
what a
proper
09
action.
yeah, what a 0995. What's the difference between 0995, 0996, and when what's needed. And I always tell people those forms have instructions at the, I think
Correct.
the 0995, like the 526, they have instructions at the beginning, like the 526. It explains what an FDC claim is and what a standard claim is.
Correct.
And we get, as vets, we go right to the application without reading some of that information. And then when we get in the process, we get ourselves in a bind and don't go back and read that. So if you submit the form, I always tell people, if you submit any form to the VA, and it's a VA form, if there's any instructions at the beginning or end of that form, you definitely want to read that form and educate yourself on what that form is, because they're giving a lot of explanation by section on each one of those forms.
No, I got you. I understand what you're saying. I was trying to find one other thing, but I don't know. It might.
Yeah. And I got another.
Brought it up.
I got another question for you, Betty. When you was a decision review officer and you had a hearing, now they're informal conferences.
Mm-hmm.
Would you do a cursory review before you called the veteran, you had that hearing or informal conference to familiarize yourself on what the veteran was doing, or you just would call them and let the vet explain why he or she was doing an informal conference or high-level review?
Okay, so I'm going to put a caveat on here. When I worked on appeals, I did legacy claims, okay? And with legacy claims, the hearing officer was allowed the time to call, to do that initial call or have the hearing, whichever, and if the veteran wanted it, because they had the ability to request it. If they wanted an informal call, we made an informal call. Now with the current process, with the higher level review, they still are required to make the call, don't get me wrong. But unfortunately, the times, I hate to say it, they're not going to receive credit until either they get no comment or an inability to reach the veteran or their dependent, and they could issue a decision. So they've changed some of the processing rules, but nonetheless, look, nonetheless, I never want to call somebody and not know at least a little bit about the claim because I'm going in their code. So when I did a hearing, I never wanted to go in their code. I reviewed the folder. When I had to do it, I did do a few informal conferences. I still looked at the folder because I didn't want to be looking stupid on the phone, or if that makes sense.
Right. Yep. Yep. And so the reason why I asked it because a lot of veterans are saying when they get to the informal conference, they're asking the individual, "Hey, did you do a cursory review?" And they're like, "No, I didn't want to dilute the process. I want to hear from you before I looked at it." And whenever
but
when
I
I
will
was
say this, Dwayne,
Mhm.
that's Betty's process.
Right.
There's nothing that tells us how to do it.
Right. Right. Now, what I was going to also say, when I was a rater and I did RVSR hearings, I made sure that like Betty said, this is something I did. I made sure I was familiarized with that claim because when you do a hearing, well, now it may be a little bit different, but back then, the veteran was sitting across the table from me. And I didn't want to look like I didn't know what the heck I was talking about or what he was explaining or she was explaining. So I would make sure I would take the time to go through and be like, okay, they want a hearing, why? And I'll look at the rating decision, rating code sheet, and be like, okay, because I want to know. And sometimes if the vet had a VSO, I would say, hey, I don't think that there's no need for the hearing if the veteran can submit this particular evidence. And if they did, then sometimes I say, okay, I'll just cancel the hearing and I'll go ahead and grant the benefit or grant the increase or whatever the case may be. That didn't happen all the time. It did happen some, but the fact of the matter is, I wanted to take time to look through that veteran's information, to Betty's point. So that was something I did. So I'm not saying everybody, at the VA in that situation has to do it. Me personally, I think that they should, but doesn't always happen. All right. So I don't want to take up, I know we're a little bit over time. I want to be respectful of Betty's time and everybody else. So I will allow, and if everybody say thank you to Betty, because I threw a couple of questions at her that, kind of out of left field, try to keep it simple, but it was just some things that I've seen veterans, some basic questions that are getting veterans in trouble with their claims. So I'll go ahead and allow one more question. Then we'll go ahead and wrap this up.
Since you guys were raters, you know how when you get your decision letter, it says if you want to increase to the next rating, it gives you, because you didn't meet that criteria, it gives you like 2 or 3 lines. How many of those, for example, 2 or 3 sentences you have to meet? Do you have to meet all 3, meet all 4, or when you guys are rating for an increase?
So I will say, you do not have to meet. I mean, there's a case law out there. I can't tell you what it is at this moment, just because I can't remember the case now. But that says basically you don't always have to meet every instance of the criteria, depending on what the condition is, because basically all the regulations are written with law. So you have to look to say, does it say and? Does it say or? I mean, those things are critical as far as law of what they can and cannot do. And so if that makes sense, I mean, no. So I'll use a mental examination, like I said, for a mental condition. Do I have to meet every criteria at the 30% level to get 30%? No. But it can look, so here's the problem with that. So sometimes it looks like that person may reach the 30% criteria, but then the examiner, without any other additional medical evidence, may say, yeah, but it's not impacting that person to this level. And so what may look like a 30% could end up being a 10%. So I can't say, conclusively that whatever you're claiming, it depends on what the condition is and the law criteria that governs that condition, if that helps.
Yes, thank you.
And if
You're
you go
welcome.
to one of the rating criteria I can just think of right off the top of my head, it's a general rating criteria for skin condition. You'll see what she's talking about when it says, and I think like when you get into 30, 60%, it's 4 different criteria. It'll say and then it'll get to or, and it'll list something in or. So you don't have to meet all those, but be careful in reading it. And that's one thing when I started rating, that's one thing that it used to trip me up all the time. And when I was in challenge training, Betty was one of my instructors. And I'm gonna tell you, she'll tell you too, I was having a hard time. I was like, man, I'm not getting it. And we got back to the hotel, we went out and I think the courtyard or something, wasn't it, Betty? And
I took you out to the courtyard, sat
yeah,
there, and then we was like, I just broke it down. Hey,
yeah,
A, B, C, D.
yeah, I was like, I wasn't getting it. I'm like, man, I was,
Sometimes it's A, B, C, and then sometimes it's just A to Z.
yeah.
And so, and then once we did it, he was good, and I think he did all right. So
Oh, you think, huh?
I'm gonna say this, look, guys, I'm not gonna be rude, but I'm gonna say it. I'm gonna get ready to get off of here only because I'm going to see Brian Culberson tonight, and you can edit this out the video, but I need to go make sure that everything
Okay.
is gonna be okay.
Okay.
No,
Well,
but
Betty,
hopefully I provided everyone with some information they can use.
yeah. Well, we definitely
And
appreciate it, Betty. Thank you for taking the time. I'm pretty sure the veterans on here today. If you want to say thank you in person to Betty, go ahead and mute your mics. And I'm going to put this on YouTube. And I'm pretty sure other veterans will find it very informative as well.
So, Miss Betty, I want to thank you for your time and your expertise and speaking with us today. And I appreciate you and your service and enjoy that concert.
I am. It's been a year and a half in the making. They kept canceling it. COVID.
Okay. All right. I'll stay on for a couple of minutes more if anybody got any other questions. But Betty, I definitely appreciate it and enjoy.
You're always welcome. Thank you, guys. Y'all have a great day, evening. I don't know the time zone, so whatever it is, have a great one.
You too,
You
God
too.
bless.
And
Now,
thank
thank
y'all for
you.
y'all.
Okay, thanks.
Oh, and thank y'all for your service too. Thank you. All right. Bye-bye.
Bye.
Bye.
Bye-bye.